Good afternoon, students. Today is Monday, 4 April 2022. We're about to begin, I guess it's the seventh item of the 9 items that we'll be covering this semester. We're going to be reading and discussing for the next 3 class periods an actual U.S. Supreme Court case. Earlier in the semester, we discussed a hypothetical case, the Spelunkers, and then we took up an actual case called Cohen versus California. So this will be our second Supreme Court opinion of the semester. Now I chose a court opinion that is fairly short. Some of them are much longer than this one. It does have a dissent, at least one dissenting opinion, and I chose that because I want you to see how when the court is split, you can see different arguments, one on this side and one on the other side. In fact, there are 2 dissents in this case, and we'll be discussing both of them. In fact, I'm going to divide up the material as follows. Today, we'll discuss the majority opinion written by John Paul Stevens, and then later this week, in our second lecture of the week, we'll discuss the dissenting opinion by William Rehnquist. And at this time next week, Monday, we'll discuss the second dissenting opinion by Antonin Scalia. So that divides it up pretty neatly. We'll discuss one opinion each of the 3 days we discuss this case. Now, I've posted 3 items since the exam. The first item is the case itself. Now, here's my copy. I didn't staple this one together, so it'll go in my notebook. And it's about 50 pages long, so I hope you have that in front of you, or at least I hope you've read it carefully by now. The second item that I've posted is a 2-page handout entitled Eighth Amendment Cases. I have mine copied on 1 sheet of paper. And the third item, which I've posted just this morning, is my lecture notes on this case. So you may want to pause the video right now, print my lecture notes, and have them in front of you as you watch the video. And then you can make notes in the margin and so on. Okay, I want to begin our discussion with this handout. The title of this handout is Eighth Amendment Cases. So let me provide some background information about the Eighth Amendment. The Eighth Amendment to the United States Constitution was ratified on 15 December 1791, along with the other 9 amendments that make up the Bill of Rights. Virginia was the 11th state to ratify, which completed the ratification process. Now, the Eighth Amendment provides as follows. It's quite short. It says, quote, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted, unquote. Now, these 3 clauses have been given names by lawyers and judges. The clauses are known as the excessive bail clause, the excessive fines clause, and the cruel and unusual punishments clause. This case that we're about to start discussing today concerns the 3rd clause, the cruel and unusual punishments clause. Now, that clause was incorporated, and now you know what that term means. The cruel and unusual punishments clause was incorporated or made applicable to the states in 1962 in a case called Robinson versus California. What that means is that not only the federal government, but every state is prohibited by the Constitution from imposing cruel and unusual punishments on its citizens. Now, this handout is just a few of the many cases that have come down over the years from the United States Supreme Court. And I chose those cases that have to do with punishing people who have certain characteristics, punishing with death. In 1986, as you can see here, the court took up the question of whether someone who is currently insane may be put to death as punishment. Someone who's been convicted of murder in a court of law, but is now insane. it may be that the insanity came on after the conviction and sentence. In the court in that case, which is known as Ford versus Wainwright, the court said, and I'm quoting now, the Eighth Amendment prohibits the state from inflicting the penalty of death upon a prisoner who is insane. And that opinion, that case, to my knowledge, has never been overruled. So that's still good law. No state, and that includes the federal government, may put to death someone who is currently insane. Now, that person will, I'm sure, be kept in prison and be given treatment for the insanity. So all this says is that a particular punishment, namely death, is prohibited by the Eighth Amendment of the Constitution. Now, what about age? Has the court ever restricted capital punishment for people of a certain age? There are 3 cases reported on this handout of mine. The first is Thompson versus Oklahoma. This case, which was handed down in 1988, said the following: the 8th and 14th Amendments prohibit the execution of a person who was under 16 years of age at the time of his or her offense. So, in the case of Ford versus Wainwright, the question was whether someone who is currently insane may be put to death. This case, Thompson versus Oklahoma, is different. It's whether, in 2 ways. It's whether someone of a particular age may be put to death by a state or by the federal government. And the age has to do with the time at which the crime was committed, not the current time of the appeal. So what the court said is, unless you're at least 16, you may not be put to death, no matter how heinous your murder or murders may be. You can, of course, be institutionalized or confined for the rest of your life. Now, that case was effectively, that case is still good law. The issue of whether a person of a certain age may be put to death came up again in 1989, only 1 year later. And the issue in that case was whether someone who committed a crime at the age of 16 or 17 years of age may be put to death. And the court said, yes. The court said, we discern neither a historical nor a modern societal consensus forbidding the imposition of capital punishment on any person who murders at 16 or 17 years of age. Accordingly, we conclude that such punishment does not offend the Eighth Amendment's prohibition against cruel and unusual punishment. So what do we have now? We have one case that says you can't put to death someone who is under 16. The second case said you may, if you choose, put to death someone who is 16 or 17 years of age. Now you may be wondering about 18-year-olds. Well, 18-year-olds are of age. They're adults under the law. So they may, like any other adult, be put to death if they commit a capital crime and are sentenced to death as a result. Now there's one more case besides those 2. In the year 2005, which is only, 16 years after the 16 years after the case of Stanford versus Kentucky that I just mentioned, the court took up the issue once again of whether 16 and 17-year-olds may be put to death. Okay? Only 16 years later, the court took up the same issue. And this time the court ruled that the Eighth Amendment prohibits putting to death anyone under 18 years of age. So here's what the court said. And I'm looking at page 2 of my handout. This is the case of Roper versus Simmons. The court wrote, this case requires us to address for the second time in a decade and a half whether it is permissible under the 8th and 14th Amendments to the Constitution of the United States to execute a juvenile offender who was older than 15 but younger than 18 when he committed a capital crime. Well, what does it mean? Older than 15 but younger than 18? It means either 16 or 17 at the time the crime was committed. The court then added, in Stanford versus Kentucky, 1989, a divided court rejected the proposition that the Constitution bars capital punishment for juvenile offenders in this age group, which means 16 and 17. We reconsider the question. The 8th and 14th Amendments forbid imposition of the death penalty on offenders who are under the age of 18 when their crimes were committed. So you could say that this case, Roper versus Simmons, upheld Thompson versus Oklahoma with respect to those under 16 years of age, and it struck down Stanford versus Kentucky, the case handed down 16 years earlier. So the law as it currently stands in 2022 is that no state, and that includes the federal government, no state or the federal government may put to death someone who was below the age of 18 at the time his or her crime was committed. And that's the law of the land. So the court finally got that sorted out. Now that could be changed at some future point, maybe when the composition of the court changes, the court may overrule this case of Roper versus Simmons and hold that states may, if they so choose, put to death individuals who are 16 or 17 or even 15. So it's never out of the question for the court to overrule itself. You can see that it's done so here on this question of age. So now let's get to the topic of the current case that we're about to discuss. Let's go back to 1989. In 1989, in the case of Penry versus Linaw, and I'm reading from the first page of my handout, the court ruled that states may, if they so choose, put to death individuals who were mentally retarded at the time the crime was committed. Mentally retarded. That's not the same as insanity. So we're not talking about insane people. We're talking about people who are, as the court put it, mentally retarded. And you can read what the court wrote there. No, the court didn't require that states put to death the mentally retarded. It said that states may, if they so choose. In other words, the court ruled that the Constitution of the United States, the 8th Amendment, as incorporated by the 14th Amendment and made applicable to the states, the court ruled that the Constitution allows states to put to death people who were mentally retarded at the time their crime was committed. This case, Atkins versus Virginia, raises that issue all over again. And as you may expect, the court overruled Penry from only 13 years earlier. So Penry was handed down in 1989. In 2002, in the case that we're about to discuss, the court overruled Penry. The court said in Atkins versus Virginia that a state may not, even if it wants to, it may not put to death someone who was mentally retarded at the time the crime was committed. Now, I'm not going to read that paragraph. You can if you want to. You may if you want to. But we're going to be discussing it. So I'm going to put this handout aside and we're going to get right to it. Okay? We're going to discuss this 2002 case known as Atkins versus Virginia. Now, I mentioned a moment ago that in a period of only 13 years, the court overruled itself. You may ask yourself, what changed in 13 years? Well, one thing that changed is the composition of the Supreme Court. And I have a list here of some of the changes. Clarence Thomas replaced Thurgood Marshall. Thurgood Marshall had said that capital punishment violates capital punishment of the retarded, violates the Eighth Amendment. Clarence Thomas disagreed and said, no, it doesn't. So that's the first change. Secondly, Ruth Bader Ginsburg replaced Byron White. Justice White had said, no, the Eighth Amendment does not rule out capital punishment of the mentally retarded. Justice Ginsburg said, yes, it does. Third, Justice David Souter replaced William Brennan. Both of them had the same view. Yes, the Constitution rules out capital punishment of the retarded. Fourth, Stephen Breyer replaced Harry Blackmun. And they both answered yes to the question, does the Eighth Amendment prohibit the execution of mentally retarded individuals? So what really changed in the interim is that two of the justices, Sandra Day O'Connor and Anthony Kennedy, switched sides. They changed their minds in a 13-year period. They both went from no to yes. In Penry, they both said that the Eighth Amendment does not forbid putting to death retarded individuals. By 2002, in Atkins, they had changed their mind and said, yes, it does. The Eighth Amendment, as made applicable to the states by the 14th Amendment, does prohibit the imposition of the death penalty on individuals who were mentally retarded at the time their crime was committed. Unfortunately, neither of them wrote separately in Atkins to explain the change in their judgment. It would have been interesting, wouldn't it, to see what they said. What exactly changed their mind, in other words? Was it new facts that have come to light? Did the factual situation change in 13 years? Perhaps a new argument had come about that persuaded them to change their minds. But again, we don't know because they didn't write separately to tell us. By the way, I've been using the term mentally retarded because that's the term that the court used, both in Penry in 1989 and in Atkins in 2002. Now, this case was handed down 20 years ago. In fact, let's be more specific. If you look at the first page of the opinion, you'll see that it was decided on June 20th, 2002. Now, today is the 4th of April. So this case we're about to discuss was handed down almost exactly 20 years ago. And a lot has changed in 20 years. Obviously, you may have been born in that 20-year period. One of the things that changed in the past 20 years is terminology. Now, let's read the first footnote of my lecture notes. It's from Wikipedia. It's from the Wikipedia entry entitled Intellectual Disability. And here's what it says there, or at least it did as of a year or so ago when I quoted it in the lecture notes. The terms used for this condition, now they're referring to what they call intellectual disability. The terms used for this condition are subject to a process called the euphemism treadmill. This means that whatever term is chosen for this condition, it eventually becomes perceived as an insult. The terms mental retardation and mentally retarded, were invented in the middle of the 20th century to replace the previous set of terms, and I put in brackets some of those terms. The law is filled with the terms imbecile and idiot. I didn't make those up. Those were terms used in legal proceedings, in court opinions, even in statutes. They're in many, many law books, and they always will be, right? They were published in those books, and as long as those books are around, those terms will appear in them. But those terms have come to be perceived by some people as insulting. And so, according to the Wikipedia entry, these terms, such as imbecile and idiot, were deemed to have become offensive. By the end of the 20th century, terms like mentally retarded themselves have come to be widely seen as disparaging, politically incorrect, and in need of replacement. The term intellectual disability is now preferred by most advocates and researchers in most English-speaking countries. So I suspect that if this case had been decided today, the court would not have used the term mentally retarded, but it would have used the term intellectually disabled. Okay, so I put in a footnote about terminology. I may well continue to use the term mentally retarded simply because that's the term the court used in this case. All right, are you ready to get started? We are about to start discussing the majority opinion in this case. Later this week, we'll take up the first of two dissenting opinions, and at this time next week, when we complete our discussion, we'll take up the second dissenting opinion. Now, the majority opinion was written by John Paul Stevens, who's no longer on the court. He was joined in this majority opinion by Justices O'Connor and Kennedy. Remember, those two switched sides. Souter, Ginsburg, and Breyer. And they think of them as the 6 members of the majority. Okay? Now, I have noted here to myself, the majority opinion takes up 16 pages of the actual published opinion. So let's get started. In my lecture notes, you can see that the majority opinion takes up 2.5 pages. I'd like to get through it today. If we don't, that's okay, because the first dissenting opinion is fairly short. So if we don't get through the majority opinion, we'll just tack it on to what we were already going to discuss on Wednesday. So what's the issue in this case? The question or issue presented by this case is as follows, and I'm going to quote from the majority opinion on page 307. The issue is, quote, whether such executions, and the court is talking about those involving mentally retarded individuals, whether such executions are cruel and unusual punishments, and therefore prohibited by the 8th Amendment to the federal Constitution. Actually, as you now know, it would be the 8th and the 14th Amendments, because this is the state of Virginia putting someone to death, not the federal government, or trying to put someone to death. And the 14th Amendment is the amendment that makes the 8th Amendment applicable to states like Virginia. We've already been over that when we discussed Cohen versus California. Now, we've already read the 8th Amendment. You can see in my notes that says read it aloud. We've already done that. And we've already discussed briefly its 3 clauses. We're concerned with the cruel and unusual punishments clause. Notice something interesting. The 8th Amendment could have said that execution or putting someone to death is prohibited. It could have specifically addressed the death sentence, and it did not. What it did is it used the term cruel and unusual punishments, leaving open whether that includes or excludes the death sentence. So the court has had to interpret that language in many cases over the years. Does the term cruel and unusual punishments include putting someone to death? Yes or no? And the court has been on different sides of that question over the years with regard to age, insanity, and mental retardation. So here's my query. A query is a question. And when you see that word in my lecture notes, that means it's a question I would like to ask the court, if I could. It's a question that came to mind as I was reading the opinion. not just any old question, but what I consider a good question, a question that's significant, that goes to the heart of the issue. Here's my query. How is it possible for someone to be responsible enough, legally responsible enough, to be tried, in other words, put on trial, convicted of committing a crime, and sentenced to some form of punishment, but not responsible enough to be punished by death? It's a puzzle, isn't it? You might think that people who are only 15 years of age are not responsible enough even to be put on trial. They may be institutionalized because they're dangerous, or in order to rehabilitate them before they're released. But why do we even put them on trial if they're not responsible? Do you see the point I'm making? How can somebody be responsible enough to be tried, convicted, and sentenced and punished, but not responsible enough to be put to death? That's a real puzzle. And unfortunately, the majority never answered that question. So we're left to speculate about why. It's a kind of threading of the needle, isn't it? We're trying to thread the needle between being responsible enough to be tried, convicted, and punished, but not responsible enough to be put to death as a form of punishment. Now, Stevens, if writing for the majority, John Paul Stevens, I don't mean any disrespect by just calling him by his last name, and I don't think he would take any offense to that. So just to shorten it, I'll call him Stevens. Stevens says that mental retardation creates, quote, disabilities in areas of reasoning, judgment, and control of impulses, unquote. So Justice Stevens thinks that when a person is mentally retarded, that person suffers from lack of responsibility. That person probably is unable to reason as well as someone who's not retarded, probably is incapable of forming sound judgments about what to do or whether to do something. And third, is probably unable to some degree to control his or her impulses. So Stevens thinks that retardation is linked to responsibility, or what we might call culpability. Culpability is from the Latin word culpa, which means to blame, blameworthiness. So Justice Stevens seems to think that mentally retarded individuals who commit crimes are not as blameworthy as someone who committed the same crime but was not mentally retarded at the time. Okay? So Justice Stevens thinks that the mentally retarded are less culpable than those who are not mentally retarded. Now, I'm currently just summarizing Justice Stevens' opinion. We'll look at the details in a moment. If you look at the top of my page 2, you'll see that I wrote the following. Penry, the case of Penry, which is from the handout we went over earlier, Penry had been decided 13 years before, in 1989. But since then, Stevens says, there has been deliberation by, quote unquote, the American public, legislators, scholars, and judges, unquote. So Stevens is suggesting or saying that in the 13 years since the court previously addressed this issue, things have changed. Scholars, legislators, judges have reconsidered the question of putting to death the mentally retarded. Remember, when I say putting to death the mentally retarded, I'm talking about people who were mentally retarded at the time they committed the crime. In the insanity case, Ford versus Wainwright, the issue was different. It was whether the Eighth Amendment prohibits putting to death someone who is insane at the time of the execution, not at the time the crime was committed, which may have been years earlier. Okay, now here I think in a nutshell is Justice Stevens' reasoning. He begins with the text of the Constitution, the Eighth Amendment. He then interprets that text based on Supreme Court precedents, previously decided Eighth Amendment cases. The Eighth Amendment, according to Justice Stevens, prohibits excessive sanctions. That is, it requires a certain type of proportionality between two things: the seriousness of the offense and the severity of the punishment. Now, I have in my notes, use a diagram. If I had, if you'll bear with me, I have a piece of paper here, a blank piece. Maybe I should have done this before I got started. Let me find a pen that works, and I'll make a little diagram for you. If I had a blackboard, I would put it on the board. Okay? Whoops, I happened to pick a pen that doesn't work. Maybe I should get rid of that. Let me find another one. Try this. 0 for 2. Okay, let me try. What is that thing? I don't even know what that is. I've got a whole container of pens. There we go. This one worked. You can see what I'm reaching for here. Quite a few. Okay, what I've done is drawn two vertical lines. I'm going to write on the left side, seriousness of the offense. Seriousness of offense. And on the other scale, and I'll show you this in a moment, I'm going to put the severity of punishment. Severity of punishment. Okay, here's what I've got so far. You see that? Now, at the top of these vertical lines, think of that as the highest degree, and at the bottom down here, think of that as the lowest degree. So I'm going to put plus signs near the top and minus signs at the bottom. See that? Now, the idea is this. The idea is that when we punish, we should punish people in proportion to the seriousness of the crime they committed. So if a crime is near the top of this scale, where my finger is, then if we go straight across, we should punish that person severely, right? So any line that's perpendicular, that goes straight across, would reflect proportionality. That means the severity of the punishment is proportional to the seriousness of the crime. Now, what if the crime is low on the seriousness scale? It would be down here, somewhere down here. Proportionality means that we should punish less severely for that crime. So I'm going to draw a whole bunch of perpendicular lines from left to right. I'm writing on a rough table, so the lines are kind of squiggly. But you see the point? All of those would represent proportional punishment. Now I'm going to draw a diagonal line between the two vertical lines, and that will reflect a disproportionate punishment. I'm going to draw I'm going to draw a diagonal line, and then when we discuss it, I'll put another diagonal line. Okay, do you see that diagonal line I drew right here? What that shows is that we've got a crime, up here, we've got a pretty serious offense, but we're punishing it lightly. Right? We're not punishing it as severely as we should. Right? There's a kind of injustice. You deserve to be punished severely because of the gravity of your crime, but we gave you a slap on the wrist. That's sort of what Bonnie Steinbach had in mind. She said that drunk drivers who kill commit a very serious crime, and yet our system tends to slap them on the wrist. And they deserve to be punished more severely, she argued, because they are second-degree murderers. Okay, I'm going to draw one more diagonal line. This one will be in the other direction. All right, you see that one? This one, the line right here. Whoops, right there. Here we have a crime. Let's go down. It's kind of hard doing this on the screen. Okay, I want to come down here. Here we have an offense or crime that's not very serious, but it's being punished. Whoops. It's quicker to do that. It's being punished very severely. That's also unjust. That would be like sentencing someone who's parked too long in a city space downtown, punishing that person with a year in prison. That's disproportionate. Okay, so it's a crime to park in a metered area without putting money in the meter, right? There should be some punishment for that, but surely not a whole year in prison. Really, not any time of imprisonment. It should be a small monetary fine, like $50 or something that will deter most people. So this is the idea of excessive punishment. According to Justice John Paul Stevens, the Eighth Amendment prohibits excessive sanctions. That means that we should never punish people more than what they deserve, right? We shouldn't punish excessively. That I think is all he's saying. When we interpret the Eighth Amendment, he seems to be saying we should refrain from punishing too much. We should refrain from punishing excessively. Okay, the next thing I have in my notes is I say to myself, draw a Venn diagram based on Stevens' footnote 7. So let me find that, footnote 7, and I'll show you my drawing. Here it is. This is from page 311 of the opinion. Do you see the diagram at the bottom? What I've done is I've drawn two circles partially overlapping one another. The two circles are labeled. One of them is labeled EX, and that's just shorthand for excessive punishments. So think of all excessive punishments as being in that circle, the one labeled EX. The other circle has underneath it C and U, and you can probably guess what that means. It means cruel and unusual punishments. Now, when I drew those two circles overlapping in part, what I did is I created 4 logical spaces, and I numbered them, 1, 2, 3, and 4. Category 1, which you can see there, see the numeral? Category 1 represents punishments that are excessive, but not cruel and unusual. Notice they're inside the excessive punishment circle, but they're not inside the cruel and unusual punishment circle. Category 2, which is that football-shaped area in the middle, that's inside both circles. So those would be punishments that are not only excessive, but they're also cruel and unusual. Category 3 would be punishments that are cruel and unusual, but not excessive. And category 4 would be punishments that are neither excessive nor cruel and unusual. Now here's what Justice Stevens says in his footnote. Okay, I'll turn it around so I can read it. This is footnote 7. Justice Stevens says, thus, we have read the text of the Eighth Amendment to prohibit all excessive punishments as well as cruel and unusual punishments that may or may not be excessive. So what's he saying? He's saying that the court has previously ruled in other cases that any punishments in categories 1, 2, or 3 on my diagram violate the Eighth Amendment. 1, 2, or 3. They don't cover category 4, but they do cover 1, 2, and 3. Anything in the excessive circle, and also anything in the cruel and unusual circle, or both. Okay, so that's the second thing Justice Stevens does. Now let's go back to my notes. How do we judge excessiveness? Who determines whether a particular type of punishment, such as death, is excessive for a particular crime, such as murder? According to Justice Stevens, excessiveness is judged by prevailing standards. That means the standards that prevail in society at large at the current time. He calls these evolving standards of decency. Notice something interesting. When he uses the word evolving and the word prevailing, he's implying that standards can change over time. Things that would not have been considered punishments that would not have been considered excessive, let's say 100 years ago, today might well be considered excessive because standards have changed. Right? Our standards of decency or justice or fairness have changed. It could also go the other way. A punishment that was deemed to be excessive at some point in the past theoretically could be deemed today by our new standards not excessive. So Justice Stevens is saying that we need to look at prevailing current standards, not the standards of 50 years ago or 100, and certainly not the standards of the time at which the Eighth Amendment was drafted or ratified a long time ago. Stevens says, in fact, prevailing standards are not the standards of those who drafted or ratified the Eighth Amendment. Now, this view of Stevens and the other members of the majority is sometimes called living constitutionalism. The idea is that the Constitution is alive. It's a dynamic, living, growing, and developing thing. And each generation must interpret it in light of its own values and understandings and sensibilities. Okay? That's the view of the majority. When we get to Justice Scalia's dissent a week from now, you'll see he takes a very different approach. He says we need not, and should not look at prevailing standards. We should look at the understanding of the Eighth Amendment at the time it was ratified by the people who ratified it. We should figure out how they understood the words of the Eighth Amendment. Did they specifically believe that the Eighth Amendment that they drafted as part of the Constitution ruled out capital punishment of the mentally retarded? That's the question Justice Scalia will try to answer. But right now, we're looking at a different approach, the approach known as living constitutionalism. Okay, now, next question. What's the best evidence we have of prevailing standards or contemporary values? What should we look to determine what prevailing standards are? According to Justice Stevens, the best evidence is legislation. Look at the laws that are on the books today. The laws not of 50 or 100 years ago, but laws that are still on the books. Presumably, those laws that are on the books today reflect the values of the people. In our representative democracy, the people vote, they elect their representatives at the state and federal level. Those representatives in the legislature enact laws. They can also repeal laws or amend laws that are on the books. They can change them. They can repeal them, which means get them off the books altogether so that they're no longer effective. They can keep the law but change it. That's called amending. Or they could add a new law. They could enact a new law and put it on the books. So Justice Stevens and his fellow members of the court in the majority is saying that to determine what contemporary or prevailing standards are, we should look at the laws of the 50 states and perhaps also the federal laws that are on the books, if there's one that applies to this case. Okay, so Justice Stevens wants to figure out what the will of the people is. And the way to do that is to look at what the laws are in the various states. And Justice Stevens doesn't think that that ends the inquiry. He thinks that this creates a rebuttable presumption. And that presumption is rebuttable in the sense that the court can override it. And Justice Stevens will, later in his majority opinion, after he has examined the results of his inquiry into the legislation of the 50 states, he's going to ask whether the court should exercise its independent judgment and override or rebut the presumption in favor of unconstitutionality. So, what I've done so far is sketch his reasoning. We're going to come back to it in a moment and look at it in more detail. You still with me? Let's look at the facts of the case. I say in my notes, read the marked paragraph on page 307. So let me get my opinion out. We'll read a little bit of it. Remember, the first thing we read in the course was a short article by Orrin Kerr, a law professor. It's written for law students. And he said, if you remember, it's very important to understand the facts of the case so that when it comes time to apply the law to the facts, you won't make any mistakes. You'll have a good understanding of the facts. So let's take a look at the facts. This is Justice Stevens' statement of what happened. Now, facts are always of two sorts. First of all, there are substantive facts, the substance or matter of the case. What happened? How did this case get into the court system? Somebody probably did something bad to someone. That's usually how a court case starts. Someone committed a crime and was arrested and put on trial. And it got appealed, and here we are. Okay? Or it could be a civil case where somebody believed that he or she had been wronged by someone and filed a lawsuit to recover damages. Those cases also get appealed. So, what's the substance of this case? Well, the first paragraph concerns the substance. Here's all Justice Stevens says about the substance. Petitioner Darrell Renard Atkins was convicted of abduction, armed robbery, and capital murder, and sentenced to death. That's 3 crimes. Abduction, you can think of it as kidnapping. He abducted someone. He took someone forcibly, against his or her will, away from where that person was and wanted to remain. Armed robbery. That means you're taking property, including money, from the person, and that you were armed. You had a weapon, and that's what you used to extract the money or the property. And third, murder. Not just murder, but capital murder. Not all murders are capital murders. A capital murder is typically a murder in which there are aggravating circumstances. For example, some states say if you kill a child, you have committed capital murder. If you kill a law enforcement officer, you've committed capital murder. If you kill more than one person, you've committed capital murder. Those are just examples. Capital murder is murder for which the death sentence is called for. Not all murders are punishable by death. Some are, and they're called capital murders. So Atkins was convicted and sentenced to death. Here's what he did. At approximately midnight on August 16, 1996, notice that's 6 years before this Supreme Court ruling was handed down, Atkins and William Jones, armed with a semi-automatic handgun, abducted Eric Nesbitt, robbed him of the money on his person, drove him to an automated teller machine in his pickup truck, where cameras recorded their withdrawal of additional cash, then took him to an isolated location where he was shot 8 times and killed. Now there are pictures of the 3 of them in the vehicle, in the pickup truck. I think I'll post one of the pictures on Canvas for you. It was taken by a camera at the ATM, which stands for automatic teller machine. And it shows Atkins, Jones on the outside of the pickup on the seat with Nesbitt in the middle, in between them, presumably so he couldn't open a door and get out. And they made him give him his credit card and his PIN, personal identification number, so that they could withdraw money. Now, they didn't let him go. They might have, once they got his money out of his account, they might have let him go. They chose not to. They kept him in the truck, drove him to an isolated location, and they might at that point have just let him go so that he would have to find his way back to town or to help. But they didn't. They shot him several times and killed him. So those are the substantive facts of the case. Here are the procedural facts. Procedural facts have to do with the procedures that occurred or were followed once the case got into the court system. And here you can follow along as I read on my page 2. Atkins, we know, was convicted of capital murder and sentenced to death. He appealed his sentence. Now, he would have appealed in the Virginia court system, right? He's not in the federal court system. That'll come later. The Virginia Supreme Court, at the end of this appeal process, ordered a second sentencing hearing. So the Supreme Court of Virginia must have thought that some irregularity had occurred or some mistake had been made, some error, and ordered that he be resentenced from scratch, a new hearing with new evidence in a new sentence imposed by the judge. Atkins was sentenced to death again, all over again. He appealed. The Virginia Supreme Court got the case again, and this time they affirmed his death sentence. Now, at this point, Atkins has exhausted his state court remedies. He has reached the highest court of the state of Virginia, and he lost. Now, you can't routinely appeal a case from the highest court of your state into the federal system. You can do so only when you raised a federal constitutional issue or a federal statutory issue during your trial or on appeal in your state case. And Atkins had done so. Atkins, from the very beginning, had argued through his attorneys that sentencing him to death violated his federal 8th Amendment and 14th Amendment constitutional rights. That's what allowed him to appeal to the United States Supreme Court. And he did so. he filed what's called a writ of certiorari, which is simply asking the court, would you please hear my case? The court turns down most of the writs of certiorari that are filed. It's simply unable to handle all of them. There are too many. The court is already overstretched. There are only 9 justices with a certain number of clerks, and they can hear only a certain number of cases each year. The court granted certiorari in this case, which means the court agreed to hear it. And that's how it got into the Supreme Court. And I'm not sure I've told you this, the U.S. Supreme Court reversed the Virginia Supreme Court. The United States Supreme Court, in a majority opinion written by Justice John Paul Stevens, ruled that the Eighth Amendment forbids, the Eighth and 14th Amendments together forbid imposition of the death sentence on someone who was mentally retarded at the time his or her crime was committed. Okay, so those are the substantive and procedural facts of the case. Let's now start looking at the reasoning of Justice Stevens and the other members of the majority. So I'm at the very bottom of my page 2. Justice Stevens began by pointing out that the Eighth Amendment prohibits what he calls excessive sanctions. Notice, by the way, that 2 of the 3 clauses of the Eighth Amendment contain the word excessive. Let me go get my handout. Here once again is the Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed. So 2 of the 3 clauses contain the word excessive. What Justice Stevens is doing is interpreting the Eighth Amendment as a whole to be concerned with excessive punishments. And he interprets the cruel and unusual punishments clause as ruling out any punishments that are excessive, as well as those that are both cruel and unusual. Okay? Now, as I said earlier, according to the majority, what counts as excessive depends on prevailing standards. Let me make a note here. What counts as excessive depends on prevailing standards, not the standards that prevailed, quote, when the Bill of Rights was adopted long ago. We're looking for evolving standards of decency. Those words, by the way, which are quite famous, evolving standards of decency, they come from a 1958 case called Tropp versus Dulles, or Tropp versus Dulles. Now, I mentioned earlier that there has to be a way to find out what these prevailing standards are. And according to Justice Stevens, on page 312, quote, we, the court, have pinpointed that the clearest and most reliable objective evidence of contemporary values is the legislation enacted by the country's legislatures. That's what we should look to, Justice Stevens is saying. We need to do some research, look at the laws of all 50 states, and see what position they take on putting to death those who were mentally retarded at the time they committed their crimes. Notice, he calls it objective evidence. Justice Stevens is bending over backward to say to the world, we're not just imposing our own personal moral views on this case. That would be subjective. Right? We're not just deciding this case based on our whims or our own personal moral standards. We're looking at something more objective. Objective means outside of the self, something out there in the world. Subjective means inside the person, something in your own mind, a belief or a value of your own. So that's interesting. I mention that because Justice Scalia doesn't believe it. When we get to his dissenting opinion a week from now, you'll see that Justice Scalia says, don't be fooled. The majority wants you to think that they looked at legislation, an objective fact about the world. But really, Scalia says, really they're just imposing their own subjective moral views on society. Okay? Justice Scalia is a cynic. He's questioning the motives of the majority. He's telling the reader, don't be fooled. Don't believe what they say. This opinion did not come down to anything objective. It was decided on the basis of the subjective, personal views of 6 members of the court. 6 members who, by the way, were never elected by anybody to anything. At least as judges, they weren't elected. They were appointed by the President of the United States, and they were confirmed by the United States Senate. Yes, the President and senators are voted into office, but the judges themselves weren't voted into the Supreme Court. They were appointed. So Justice Scalia would add, these are unelected judges, and they are presuming to impose their subjective preferences or values on the whole of the United States. And we'll talk more about that opinion a week from now. Anyway, Justice Stevens says, we're going to look at objective evidence. Once we ascertain what the evidence is, once we look at the laws of the 50 states, we will still have to exercise our own independent judgment on what the legislatures have done. In other words, we're not going to be slaves to the legislatures. We want to see what they've done. We consider that important evidence. But once we've determined what that evidence is, once we've ascertained the views of the legislatures, we still need to look at it on our own. And we may disagree with it. That's certainly possible. Okay, the rest of my notes show Section 3, the judgment of legislatures, and Section 4, 2 reasons why the mentally retarded should be categorically excluded from execution. In other words, he's going to make an independent judgment of what the legislatures have done. So we're an hour and 2 minutes in. I think I'm going to just cut things off after looking at Section 3. And we'll pick up next time with Section 4. We'll also look at Justice Rehnquist's dissenting opinion next time. So here we go. On page 314 of the majority opinion, Justice Stevens writes, quote, much has changed since the previous case, Penry, in 1989. Much has changed. More specifically, this is from pages 315 to 316. Ready? The large number of states prohibiting the execution of mentally retarded persons and the complete absence of states passing legislation reinstating the power to conduct such executions provides powerful evidence that today our society views mentally retarded offenders as categorically less culpable or blameworthy than the average criminal. Unquote. So, in 1989, in the Penry case, the Supreme Court said states may, if they choose, put to death the mentally retarded. Stevens says, what have they chosen to do since then? In 13 years, what have they done? He says, a large number of states since then have passed laws prohibiting the putting to death of mentally retarded individuals. And 0 states Zero, none of them have re-implemented the death penalty for mentally retarded individuals. Now, Justice Stevens thinks that is very significant evidence of something. It's evidence of prevailing standards. It's evidence of the current standards of decency in this country. Now, I have a query in this paragraph. I said, then why are they convicted of murder in the first place? You see what I'm getting at? Justice Stevens says lots of states have passed laws that say that when mentally retarded individuals commit capital murder, they may not be put to death, but presumably they may be punished severely. What's the next most severe punishment short of death? Let's say it's confinement to a penitentiary for the rest of your natural life. Okay? With no possibility of parole. Justice Stevens is suggesting that because many states have ruled out putting to death the mentally retarded, that shows some kind of lack of culpability. But wait a minute. These are people who've been duly convicted in courts of law of committing capital murder. They have been convicted, sentenced to, let's say, life imprisonment with no possibility of parole. How can they be simultaneously culpable enough to spend the rest of their lives in prison with no chance of ever getting out, but not culpable enough to be put to death for their crimes? That, again, is threading the needle, right? Threading the needle between this and what's on the other side. The very tiny little gap, maybe no gap at all, right? How do you thread that needle? Justice Stevens evidently thinks that you can. I wish he had addressed this question directly. I wish he had explained why these individuals can be culpable enough to spend the rest of their lives in prison, but not culpable enough to be put to death. He concludes on page 316 that the practice, therefore, the practice of putting the mentally retarded to death as punishment for capital murder, the practice has become truly unusual. And it is fair to say that a national consensus has developed against it. So, when Justice Stevens and the other members of the majority look at the objective evidence, which in their view is legislation in the 50 states, they see a trend, a clear pattern, a clear movement. The movement is toward eliminating the death sentence for the mentally retarded. And that allows the majority to conclude that we have a consensus in society. The prevailing standard is no death for those convicted of capital murder while being mentally retarded. I was going to make another comment. Well, maybe it'll come back before I close today, maybe not. But I think I'm going to stop there. My voice is shot, for one thing, and I want to let it rest. But why don't we pick up with section 4 on page 3 of my lecture notes. And once we get done with the majority opinion, we'll move along to the first of two dissenting opinions, the one written by Chief Justice William Rehnquist. Okay, so what do you need to do before the next lecture? If you have not already read the opinion itself carefully, slowly, making notes as you go, do so before you sit and watch the next video. Also, print and look over my lecture notes and have them ready so you can follow along as I lecture. And you may also want to read this handout entitled Eighth Amendment Cases. Okay, that's it for today. Took an hour and 10 minutes. Have a great day, and I'll see you on the screen Wednesday. So long.